Did you know that crime victims have the right to be heard? The Ninth Circuit Court of Appeals once observed that the criminal justice system has long functioned on the assumption that crime victims should behave like good Victorian children, seen but not heard. The Crime Victims' Rights Act sought to change this by making victims independent participants in the criminal justice process. One significant way that victims are able to independently participate is through their right to be heard, which ensures that their voice and story are not lost. The Federal Crime Victims' Rights Act provides that victims have the right to be reasonably heard at any public proceeding in the district court involving release, plea, sentencing, or any parole proceeding. The right to be reasonably heard is intended to allow victims to address the court directly at these proceedings. Most states have a similar provision in their state constitutions or statutes affording crime victims the right to be heard. While many people think the right to be heard is just about victim impact statements at sentencing, the right to be heard is much broader than that in most jurisdictions. It can include the right to be heard by the court at release hearings about the victim's safety, at hearings that impact the victim's privacy, such as rape shield hearings, and at dispositional hearings, such as motions to dismiss charges or plea hearings. State laws specify in which proceedings victims or their attorneys can speak to the court. It's a good idea to check with an attorney or contact NCVLI for more details about what your state law provides. The right to be heard is intended to ensure that victims are active participants in the administration of justice, to ensure that courts do not discount how crime impacts victims, and to force the defendant to hear from the people his or her crime affected. With regard to victim impact statements, if the victim chooses not to address the court directly, most jurisdictions will make alternate arrangements for the victim to be heard. For example, victims may have the option to make a phone call to the court, or submit a letter, PowerPoint presentation, or a video recording. So what are some examples of how victims can exercise their right to be heard at sentencing? State laws frequently list specific topics for victims to address, although victims are not restricted to only discussing the topics listed. For example, Oregon law provides that at sentencing, victims have the right to express their views concerning the crime, the person responsible, how the crime impacted them, and their opinion on restitution and compensatory fines. Other states provide that victims may explain the nature and extent of the trauma that they've suffered, economic loss or property damage that resulted from the crime, and if they've received any compensation for their loss. Victims can even recommend an appropriate sentence for the defendant in many cases. We've been discussing victim impact statements and exercising the right to be heard at sentencing, but it's important to remember that this is only a small part of the right. Victims' right to be heard is also a powerful tool to help effectuate victims' other rights. For example, victims can present their own opinions regarding their claim for restitution. As with all rights, while a victim can exercise the right to be heard him or herself, the victim may also have an attorney. It's important to remember that the prosecutor represents the state in criminal proceedings, and so the crime victim's interests may not always align with the prosecutor's interests. As always, victims have a choice whether they want to be heard. Even if a victim chooses to waive his or her right to be heard, he or she can still choose to take advantage of other victims' rights. The right to be heard is an important participatory right, and exercising the ability to choose whether to be heard can be important to victims. Now you know a little bit more about the right to be heard. For more information, NCVLI has published a number of in-depth bulletins, including one that addresses 12 common victims' rights. These are available for download on our website in the Law Library. NCVLI can also provide more specific information and resources to members of the victims' rights community. To submit a request for assistance, please visit our website and fill out the online request form. Victims deserve to be treated fairly in the criminal justice system. NCVLI is here to help.